This is not financial advice, not legal advice, for entertainment, educational purposes only, and anything I say is my opinion. Please don't make any financial decision based on anything I say in these videos. Listen, double check you're still subscribed to the channel, double check your notifications are on, and if you hit that like button, double check it's working properly, because you know these bad actors are working overtime to suppress the channel because they're terrified of more people becoming aware of all the fraud and corruption in the United States stock market. Guys, listen to me. A lot of people been asking me about what it is that happened in the 11th Circuit Court that made me have to file that motion for a rehearing and an in-bank rehearing, okay? What happened is the courts have rules that are put in place that are supposed to be applied to everybody universally. That's how the rules are supposed to be applied. But somehow the district court has held that the large financial institutions don't have to follow the same rules as everybody else in the courtroom. And then the 11th Circuit agreed with them that everybody else in the United States of America has to follow these rules, but somehow the large financial institutions don't have to follow those rules. And that is something that the courts are not supposed to allow. All the rules are supposed to apply to everybody equally. There's a 12B rule in federal courts, and it says that if you're served, you have 21 days to reply with a motion to dismiss. If you waive service, you have 60 days to file a motion to dismiss. But what the district court did, the district court allowed the big financial institutions, Citadel, Ken Griffin, and the other guys to file a motion that expired 2.5 years ago. Okay? Nobody else on this planet would be allowed to do that. And not just that, the rules are very, very clear. If you want to file this motion late, you have to get permission from the court to do so. You have to request permission from the court. You can't just file it. You have to request permission, and once permission is granted, then you could file it. But also, the courts have held that once a trial date is set, mediation is set, and discovery is in progress, you can't file those motions. But somehow the district court said, well, they didn't say, they allowed it. The district court allowed Ken Griffin and Citadel to file a motion that in any other court, it would have expired. And let me give you a good analogy. Let's say you're sitting for an exam, and the exam is 60 minutes. And then you decide you need more time. You can go and ask permission for more time, and the examiner could grant it or not grant it. But you can't wait till the 60 minutes is up and then want to stay 2 hours, 5 hours, 10 days later taking the exam. Would that be fair to all the other people that was taking the exam? Of course not. It would give you an unfair advantage. It's like you and I are playing a game of basketball. And I used to have a little game. I used to be a little nice, had a little jump shot, a little crossover. But let's say we're playing ball, and now the clock has run out. It went to 0, and you are losing. Then you know what you do? You go and put more time back on the clock so that you can continue to play. Would that be allowed? Of course not. But that is what the district court allowed Ken Griffin and Citadel to do, and nobody else in any district court would be allowed to do that. No way in any circuit court would that be allowed, and the Supreme Court has ruled multiple times that that's not allowed. But somehow the district court in South Florida allowed that to happen. And I saw it was totally against federal rules that are written in stone. And not only that, you are not allowed to file those motions after a order to start trial, or order for mediation and discovery. It is too late to file those motions. The Supreme Court has held that. The 11th Circuit Court has held that. But somehow they ignored the federal rules, and the ones who benefited from that is the big financial institutions. Explain to me how these decisions are not given the appearance that there are rules for everybody else and there are rules for the financial institutions. And our court system is not supposed to work like that. This is causing a major upheaval in the 11th Circuit. And I'm going to tell you why. Because now that they have affirmed that Rule 12B is not mandatory, Rule 6B is not mandatory, that after trial has been ordered, you can file dispositive motions. At this point, anybody who feels they're about to lose a trial and they're under the 11th Circuit, according to this ruling by the 11th Circuit, they could just file a motion to dismiss and not go to trial. How is that fair to plaintiffs and defendants through Georgia, Florida, and Alabama that fall under the 11th Circuit? This is a type of procedural inconsistency that requires the Supreme Court to step in and make clarifications. I have never seen this before. It is absolutely beyond my scope of understanding. It's beyond my scope of understanding how you have clear, decisive rules in place that are mandatory in every federal court in the United States of America, but somehow in the Southern District of Florida District Court, it's not mandatory when the defendants are big financial institutions. And then the fact that the 11th Circuit affirmed the lower court's decision, it sends a message all through the 11th Circuit that the rules only apply to everybody else. And if you're a big financial institution, or if you have deep pockets, well, I won't even say the rules will be applied differently. There are no rules, because the rules are very, very clear when it comes to procedural law in federal court. And somehow the district court, in my opinion, got it wrong. And now it seems like the 11th Circuit got it wrong. But that was the purpose of my rehearing motion, my in-bank rehearing motion, because the courts are going to have to look at the decision that they made and explain why they ignored clear and decisive federal procedural law and even case law in the 11th Circuit and the United States Supreme Court. Anyway, please leave some comments. Tell me what you think. Why do you think the Supreme Court not the Supreme Court, the 11th Circuit Court made a decision that gives the appearance that large financial institutions don't have to follow federal court procedures. Anyway, have a great day. God bless, and I appreciate y'all on this journey with me.